Uruguay is a nation of profound historical depth and proud legal traditions. Today, it stands as a model of democratic governance and social stability in South America. Located between Brazil and Argentina, the country's strategic geographical position has shaped its unique historical trajectory. While many outside of South America may struggle to locate Uruguay on a map or recount its celebrated past, the nation of 3.5 million people consistently ranks high in numerous global metrics. Known for its robust democracy, Uruguay proudly stands at the forefront in the Economist Intelligence Unit's Democracy Index, where it is often cited as one of the most democratic nations, not just in Latin America, but globally. Uruguay also shines in quality of life metrics. It boasts one of the highest Human Development Index scores in Latin America, reflecting significant advancements in health, education, and income. These accomplishments underscore Uruguay's commitment to fostering an equitable society where all citizens have the opportunity to thrive. Despite its modest size and often quiet presence on the international stage, Uruguay commands respect for its stable governance, progressive policies, and high standard of living, making it a model of success worthy of global recognition. But Uruguay harbors a lesser-known, yet significant challenge that remains largely invisible to many of its own citizens, hidden by linguistic and educational barriers. Uruguay stands out as one of the few nations in the world that does not grant full nationality to immigrants who become naturalized citizens. Instead, these individuals are designated as legal citizens. They are voters and permanent residents without Uruguayan nationality. Despite lacking Uruguayan nationality, in an odd twist of international practice, Uruguay provides these legal citizens with Uruguayan passports, but will not indicate the legal citizens are nationals of the nation granting the passport, that is, Uruguay. This unique classification creates a distinct separation between those who consider themselves natural citizens and therefore nationals and those who have chosen it as their new homeland. While legal citizens enjoy many of the rights afforded to natural Uruguayans, the terminology reflects a deeper societal and legal distinction that can affect their sense of belonging and identity within the nation. This denial of nationality may sound academic or remote, but the recent heartfelt testimony of Uruguayan legal citizens before the Inter-American Commission of Human Rights underscores its profound impact. Gulnor Sarat-Bakova, a legal citizen of Uruguay, originally from Tajikistan, stands as a striking example. After fleeing the brutal civil war in Tajikistan, she settled in Uruguay, following her marriage to a Uruguayan. Despite having lived in Uruguay for 24 years, integrating into its society, paying taxes, and raising her children there, she remains unrecognized as a Uruguayan under current laws. Neither does she have Tajik nationality. The emotional and psychological toll of being stateless means living with constant uncertainty and fear of being detained or deported to Tajikistan, a country where she would face persecution due to her ethnic background. Her story shows the harsh realities of being in limbo, stripped of a secure national identity despite her deep roots in her adopted home. Another legal citizen, Arvand Azizuddin, shared with the Commission his distressing experiences arising from the same nationality issues. Having moved to Uruguay from Iran, and having chosen Uruguay as his new home for its celebrated human rights stance, Arvand finds himself marginalized due to the Uruguayan passport that incorrectly marks him as Iranian. This has led to numerous complications while traveling, such as being detained and interrogated by immigration authorities, which humiliatingly separated him from those with whom he traveled and subjected him to treatment akin to a criminal. Moreover, this erroneous designation blocked him from basic financial services within Uruguay, as local banks refused to open an account for him based on his supposed Iranian nationality. Arvand's experiences paint a vivid picture of the practical challenges and emotional pain inflicted by Uruguay's restrictive nationality policies. even affecting everyday activities like banking and free movement, which most citizens take for granted. There are so many more human stories like these, but together, these two presentations from Gulnor and Arvand highlight not just the legal anomalies of Uruguay's nationality laws, but also the human suffering they cause. They illustrate the deep emotional scars left by a policy that denies individuals their rightful identity and the security that comes with it, casting shadows over their lives and contradicting Uruguay's international image as a defender of human rights. Uruguay, celebrated for its democratic values and human rights leadership, confronts a challenging paradox in its treatment of immigrants. The nation's policy denies nationality to immigrants, stateless individuals, and children born before their immigrant parents arrived in Uruguay. This stance is notably incongruent with Uruguay's historical advocacy for rights and inclusion. According to the Inter-American Human Rights Commission, the right to nationality and a clear path to naturalization are fundamental, non-derogable human rights. Yet, Uruguay's current policies place it almost uniquely in the Americas, and indeed among the global community, in explicitly denying this right to its immigrant population. This raises pressing questions. How has Uruguay, a nation renowned for its commitment to human rights, come to uphold a policy that seemingly contradicts a basic human right? We must understand the implications for those designated as legal citizens but not nationals in their own country. We must question how this affects their social integration, legal rights, and personal identities. Furthermore, this policy invites scrutiny regarding Uruguay's adherence to international treaties, including the American Convention on Human Rights, to which it is a signatory. The convention provides for the right to nationality, posing a legal and ethical conundrum for Uruguay on the international stage. These are the issues at the heart of our investigation. As we delve deeper, we will explore the impacts of this policy not only on those directly affected, but also on Uruguay's international reputation as a leader in human rights. This inquiry is crucial for understanding the broader implications of national policies that may, on the surface, seem at odds with a country's core values and commitments. 1. The history of the Eastern Bank. Before the arrival of Europeans, the land now known as Uruguay was home to indigenous groups such as the Charrúa, whose fierce resistance to foreign dominance foreshadowed the nation's later struggles for sovereignty. Colonized by the Spanish, Uruguay quickly became an arena of imperial contest. The nation's journey toward independence gained momentum under José Gervasio Artigas in the early 19th century, who advocated for a federalist model and led the resistance against Spanish, Argentinian, and Brazilian control. The crucial year of 1825 marked a turning point with the arrival of the 33 Orientals. Their declaration of independence led to the recognition of Uruguay's sovereignty in 1828 after complex negotiations between the United Kingdom, Brazil, and Argentina. Uruguay has a rich history of immigration, particularly marked by significant waves from Italy, France, and the Canary Islands, shaping its cultural and demographic landscape. During the late 19th and early 20th centuries, Uruguay emerged as a prime destination for European immigrants seeking new opportunities. The peak of Italian immigration occurred between 1880 and 1890, which was facilitated by Uruguay's welcoming policies that included incentives like housing and even free land to attract agricultural workers and their families. By the end of the 19th century, Italians comprised between 20 to 30% of Montevideo's population, significantly influencing Uruguay's culture. In Uruguay, a significant number of citizens hold dual nationality, possessing passports from Italy, France, or Spain, in addition to their Uruguayan citizenship. This phenomenon is largely due to the expansive nationality laws of these European countries, which grant citizenship based on descent, even to those born abroad and who may never have set foot on European soil. This reality poses a stark contrast and a compelling question. How can Uruguay, With such a rich tradition of welcoming immigrants and a population that actively benefits from dual nationality, justify its restrictive approach toward the naturalization of its own immigrant residents. This policy appears particularly incongruous, given that many Uruguayans themselves maintain only tenuous connections to their European ancestral homelands, and yet they hold passports from those nations, passports that indicate they are nationals of those countries, even though born in Uruguay. The issue becomes even more poignant when considering the plight of stateless individuals within Uruguay, who find themselves without a nationality in a nation that celebrates immigration history, yet paradoxically denies similar inclusion to new arrivals and their children. 2. How did Uruguay get here? This division between natural citizens as nationals on the one hand and legal citizens as foreigners who just happen to be permitted to live and vote in Uruguay is clearly articulated in a 2023 decision. In this decision, the Ministry of the Interior denied the claim of a legal citizen to be recognized as a national of Uruguay, grounding its rationale in the philosophical basis of Uruguayan nationality doctrine and natural law. According to this interpretation, nationality in Uruguay is seen as a permanent, unchangeable connection rooted in the very essence of one's origin, either through birth within its borders or through bloodline, as opposed to citizenship, which is viewed as a changeable political status dependent on residency and legal formalities. The ministry is clear and forceful.
It is essential to clarify the conceptual difference between these two conditions, that nationality and citizenship are two distinct individual conditions. Nationality is a permanent status of individuals that does not undergo any alteration, regardless of the point on the earth they inhabit, while citizenship, on the contrary, is variable and changes with the different domiciles that citizens acquire in the different societies into which humanity is divided. That nationality is the natural or original bond that links an individual to a state community, whether derived from birth, blood, or voluntary action, which produces certain consequences of law. Citizenship is a political relationship defined by the internal law of each country that grants individuals who possess it political duties and rights, such as the right to vote, hold public office, and be elected. Citing Professor Justino Jiménez de Arechaga, La Constitución Nacional.
The Uruguayan state does not hide this policy, at least within Uruguay. In 2013, the legal department of Uruguay's National Civil Identification Department issued an opinion clearly stating that legal citizens are not considered nationals of Uruguay. 5 years later, in 2018, Uruguay's Ministry of the Exterior reinforced this stance, issuing a separate legal opinion that reiterated the denial of nationality to legal citizens. Where did this unique and parochial view of nationality originate, and how is it justified in the modern world? We must turn to the third jurist, who bears the name Justino Jiménez de Arechaga, who was cited above by the Ministry of the Interior. He wrote the first edition of his multi-part work on the Uruguayan Constitution in 1946. Over the years, it has changed little, and we find the following doctrinal position stated in the volume used today.
First of all, as we have often pointed out, obtaining legal citizenship does not grant Uruguayan nationality. In American law, the institute most similar to legal citizenship is naturalization, but naturalization has the dual effect of granting the political rights inherent to a citizen plus the nationality of the country to which the naturalized person gains access. The institute of naturalization implies the recognition of the principle that individuals can change their nationality. There is a voluntary element included in the very concept of nationality. However, in our system, the notion of nationality is stricter, and changing it by voluntary act or by government concession is prevented.
The world of 1946 was markedly different from today, particularly in terms of international human rights, which have evolved significantly over the decades. Uruguay itself has undergone profound changes during this period, including the adoption of two new constitutions. Additionally, the country endured a civic military dictatorship from 1973 to 1985, which suspended the 1967 constitution, marking a pivotal chapter in Uruguay's commitment to democratic principles and human rights. And yet today, almost all of the major Uruguayan legal textbooks state the same principle dividing society into national and non-national citizens as set forth in 1946. For example, Dr. Ruben Correa Freitas writes,
"It can be concluded that the Uruguayan Constitution of 1967 distinguishes between nationals and foreigners on the one hand, and between natural citizens and legal citizens on the other. According to the constitutional text, nationality and natural citizenship are synonymous, meaning that every man or woman born in the territory of the Republic or the child of Uruguayan parents who settles and registers in the civic registry is a natural citizen and, therefore, a national."
The position persists and was officially delivered by the state of Uruguay in testimony before a United Nations Commission on November 28, 2023. On that date, a representative of the state indicated,
"When the Constitution refers to nationals, it is referring to individuals born within the territory of Uruguay or children of Uruguayan parents. Legal citizenship is for foreigners who come to live in the country."
The Uruguayan state has spoken, and we can say it has spoken clearly. 3. Organizing citizens. Many of the issues concerning the denial of nationality that seem so clear today were hidden for many years behind the Uruguayan passport issued to Uruguayan legal citizens. Until 1994, the Uruguayan passport issued to legal citizens did not label legal citizens as foreigners. Legal citizens had a nationality of Uruguayan legal citizen. But beginning in 2010 and ending in 2015, all Uruguayan passports were converted to the new machine-readable standards produced by the United Nations-affiliated standards body known as the International Civil Aviation Organization, or ICAO for short. At that time, Uruguayan officials made a crucial decision that the passports of Uruguayan legal citizens should be issued with the legal citizen's nation of birth as the nationality. The three-letter nationality code on the Uruguayan passport was changed to the code for the nation the legal citizen was born in. This was done despite the fact that many Uruguayan legal citizens are not, in fact, nationals of the nation in which they were born. Uruguay undertook to assign foreign nationalities on its passport without the permission of these other nations. Needless to say, various computer systems used by international migration authorities, airlines, and others responsible for ensuring the authenticity of passports returned errors when Uruguayan legal citizens attempted to use these new passports. Those who inspected these odd passports issued by one state, Uruguay, allegedly on behalf of nationals of other states, did not know what to make of a Uruguayan passport. After all, under the international practice of all nations except Uruguay, nations only issue passports to nationals. Why would a Cuban, Venezuelan, Iranian, or Chinese national, among many others, be traveling with a Uruguayan nationality document? If the nationality needed a visa to enter a nation, and yet those holding Uruguayan passports did not need a visa, does a legal citizen need a visa? How would a legal citizen obtain a visa issued for a Cuban passport by presenting a Uruguayan passport for the visa? Needless to say, the very purpose of the standardization regime under the ICAO was frustrated, if not broken, by the non-standard Uruguayan passport. But what is worse is that these passports returned information that the person presenting the passport was attempting to use a fraudulent passport. Families are separated at borders and in airports. Uruguayan legal citizens are detained or turned away from travel, sent home by Uruguay's unusual policy. And so, with this upgrade to the passport completed by 2015, the denial of nationality to Uruguayan legal citizens was brought out into the light. Somos Todos Uruguayos, at first the work of a small group of legal citizens, formed as an association dedicated to solving this process. Today, 8 years after its earliest work, Somos Todos Uruguayos has evolved into a potent lobbying organization that has successfully brought the issue before many Uruguayan ministries, various parliamentarians, numerous officials, certain groups within the ICAO, various nations participating in the United Nations UPR process, and then successfully sought and obtained a thematic hearing before the Inter-American Human Rights Commission on March 1, 2024, in Washington, D.C. The association has worked to support 2 proposed but unenacted laws, networked with other immigrant groups, established connections with the National Institution of Human Rights, worked with the International Organization for Migration, and worked with the United Nations High Commissioner for Refugees in Uruguay. The group and those affiliated with it currently provide information on 3 websites and work through various social media channels, including X and Instagram, to constantly raise the issues before the Uruguayan public. The group has undertaken advertising in local newspaper websites, and its representatives have spoken at university workshops on this issue. In addition, a researcher in the group has gathered passports from almost every year of Uruguayan history to prove that the current practice is not the historical practice. The research has also produced consular, ministerial, historical, and legal information that contradicts the official and current position of the state. To better describe what it seeks and the principles to which it is committed, the association has released the following statement of its purpose.
Somos Todos Uruguayos is a citizens' initiative that aims to support laws and other political and social initiatives to restore the ability of all Uruguayans, including legal citizens, to naturalize as fully protected Uruguayan citizens, to protect children's rights to nationality and equality, and to strengthen Uruguay's commitment to international law. We support the provision of information that will help Uruguayans, including our political representatives, to understand that the current unequal interpretation of Uruguayan nationality and the division of Uruguayans into classes is not supported by our history, constitution, or international commitments.
4. The thematic hearing before the Human Rights Commission. On December 3, 2023, the civil association Somos Todos Uruguayos formally submitted a request for a thematic hearing with the Inter-American Human Rights Commission regarding Uruguay's nationality policy. The comprehensive request, spanning approximately 60 pages, addressed critical issues in Uruguay's approach to citizenship and statelessness. Shortly after the submission, the association was informed that their request had been granted. The hearing was scheduled for March 1, 2024, in Washington, D.C., as part of the 189th regular session of the Commission. In anticipation of the hearing, Somos Todos Uruguayos filed a supplemental brief on February 20, 2024. This additional submission included a detailed 40-page brief and around 1,200 pages of historical exhibits, as well as proposed solutions and areas for cooperation between the state and the association. The delegation from Somos Todos Uruguayos consisted of a strong team of experts and advocates. The group included Dr. Andrew Scott Mansfield, an attorney from Massachusetts with an educational background in law and theological studies. In addition, the delegation was strengthened by Alexis Ferrand, a co-founder of the association and a former diplomat with extensive experience in development economics and international relations. Gulnor Saratbekova, another vital delegation member, brought first-hand experience of the challenges faced by stateless legal citizens in Uruguay. Arvand Azizuddin, who personally experienced the repercussions of Uruguay's nationality documentation policies, completed the team. The state of Uruguay sent a high-level delegation to the hearing, led by the Honorable Washington Abdallah, Ambassador of Uruguay to the Organization of American States. He was joined by Dr. Maite Dalmau Rodriguez, a lawyer from the Ministry of Foreign Affairs. Both representatives of the Uruguayan state, while stressing Uruguay's accomplishments concerning human rights in the past, admitted that the current nationality policy of Uruguay needed to be addressed in light of the right to nationality and, specifically, Resolution 223 of the Commission. Dr. Dalmau Rodriguez stated that Uruguay was aware that an alternative interpretation of the Uruguayan constitution was available in the work of Dr. Pérez Pérez, although she stated it was currently the minority position. Ambassador Abdallah committed the Uruguayan state to first address the issue of passports, which he hoped would be done within days, weeks, or months, and opened a discussion on how to reform the concept of nationality in Uruguay. Crucial to the ongoing work within Uruguay were the comments of the Inter-American Human Rights Commission members attending the hearing. Commissioner Andrea Pochak, serving in dual roles as the Mobility Rapporteur and the Rapporteur for Uruguay, highlighted the critical nature of the issues at hand, referencing the Commission's Resolution 223, which underscores the obligation of states to guarantee nationality and prevent statelessness. She expressed concern over the plight of legal citizens in Uruguay who cannot access nationality, pointing out the adverse impacts this has both domestically and internationally. The words of Commissioner Pochak were direct. She stated, "The so-called legal citizens in Uruguay cannot access nationality, and this results in various impacts when traveling abroad, and also some impacts living within the territory of Uruguay, for the exercise of rights and the risk of statelessness for many of these people." In her call to action, the Commissioner urged not to leave the matter solely to constitutional theorists, whose approaches might clash with international human rights laws. She stated, "The interpretation of the international law of human rights is categorical and does not admit regressive constitutional interpretations." After offering the assistance of the Commission to Uruguay so that it might comply with international law, she added, "Administrative reforms in the field of nationality within the passport are urgent." Commissioner Gloria Monique de Mace echoed Commissioner Pochak's concerns. Acknowledging an opportunity for resolution, she emphasized the urgency of the needed reforms, particularly for those currently facing restrictions. She raised a poignant issue regarding the impact on children, stressing the paradox in a region known for pioneering human rights, yet facing challenges where individuals' rights are inadvertently compromised. George Lima, the coordinator of Monitoring Section 3 at the Inter-American Human Rights Commission, which oversees 3 thematic rapporteurships: human mobility, people deprived of liberty, and children and adolescents, commended the association Somos Todos Uruguayos for initiating the hearing. Lima emphasized that both parties acknowledged the need to resolve an existing issue and discussed various methods for achieving a permanent solution that benefits all affected parties. Lima further outlined the Commission's commitment to supporting Uruguay in finding this resolution. He announced that the Commission has prioritized the issues of nationality and statelessness within its annual work matrix, particularly concerning the rights of people in human mobility situations. This focus will be closely monitored under the guidance of the rapporteur. Lima offered the Commission's technical cooperation resources to assist Uruguay, suggesting various forms of collaboration, such as visits and promotional events, to foster further discussions. José Luis Caballero Ochoa, president of the session, emphasized the importance of Resolution 223, which focuses on the right to nationality and the prohibition of arbitrary deprivation of nationality and statelessness. He urged the state to read and consider its implications. Highlighting the fundamental principles of equality and non-discrimination, Caballero Ochoa stressed that states must ensure these principles are upheld in all measures to safeguard the inalienable right to nationality and combat statelessness, avoiding distinctions based on unreasonable criteria. President Ochoa also called the state of Uruguay to heed the concept of conventionality control, which has been crucial in aligning domestic laws with international standards as mandated by the American Convention on Human Rights. He referenced the landmark Gelman case, involving Uruguay as the responding state, as an example of how the Inter-American Court has emphasized that constitutionality and conventionality control are complementary, not separate. This perspective underlines the need for Uruguay, with the help of the Commission's academic cooperation, to harmonize its public policies and legal norms with international human rights laws, ensuring compliance and advancing justice. There could be no doubt at the conclusion of the thematic hearing that Uruguay has been placed on notice. Members of the Inter-American Commission on Human Rights clearly find that the current Uruguayan practice of denying nationality to the stateless and denying an opportunity for any immigrant to become a national contravenes international law. Furthermore, by referencing conventionality control, a doctrine that indicates the decisions of the Inter-American Court of Human Rights have general applicability and binding force on all member states, the Commission indicated that Uruguay must immediately bring its practices into conformity with international law. 5. Does the future hold hope or more broken promises? Somos Todos Uruguayos, on behalf of the legal citizens of Uruguay, marches on. In the first 2 months after the hearing, the state of Uruguay has provided only 2 informal meetings with representatives of the Ministry of Foreign Affairs. Both meetings were simply introductory and did not provide a plan of action, nor did they establish an ongoing working partnership through a series of meetings as promised by Ambassador Abdallah on behalf of the state of Uruguay. Members of the association quickly returned to efforts to spread information about the impact of this denial of nationality in the international community. Uruguay was scheduled for a significant event, its 4th Universal Periodic Review, often referred to as a UPR. This was to take place at the UN Human Rights Council in Geneva. This review is part of a distinctive process that evaluates the human rights practices of every UN member state. The UPR scrutinizes national reports alongside independent evaluations, providing a comprehensive overview of human rights issues within the country. Against this backdrop, the association Somos Todos Uruguayos, led on this issue by Adriana Orvalle, spearheaded an effort to spotlight the pressing nationality issue, specifically the denial of nationality and the problematic issuance of passports bearing potentially incorrect nationalities. By collaborating with other NGOs and engaging with various nations, the association aimed to ensure these critical concerns were addressed during the UPR session. And indeed, during Uruguay's Universal Periodic Review, several countries voiced their recommendations regarding Uruguay's nationality laws and policies, highlighting the need for significant reforms to align with international human rights standards. Mexico urged Uruguay to establish a procedure for acquiring nationality through naturalization, emphasizing the inclusion of safeguards to protect against statelessness. Similarly, Brazil suggested that Uruguay should revise its provisions on legal citizenship to ensure they comply with international norms regarding the right to nationality and the reduction of statelessness. Chile argued for a unification of administrative criteria concerning the distinctions between legal Uruguayan citizenship and Uruguayan nationality. Switzerland also weighed in, stressing the importance of providing equal rights to foreigners who acquire Uruguayan citizenship through naturalization to ensure the enjoyment of human rights without discrimination and to prevent statelessness. These international perspectives highlight the global community's commitment to enhancing human rights protections and suggest a path forward for Uruguay to enhance its nationality laws, making them more inclusive and aligned with international standards. The fight for the right to nationality for legal citizens in Uruguay presents a positive example of what can happen when a dedicated group of human rights activists commit themselves to an issue. The key is to fearlessly use all domestic remedies, all domestic political opportunities, all channels of public communication, and network and connect to others within the nation committed to equality and justice. The Uruguayan struggle for nationality is an example of how a citizen group, facing domestic opposition and even disbelief, can appropriately and quickly use international treaty dispute bodies and international commissions or courts to require a nation to pay attention, listen to a broader international community, give weight to the requests of its own citizens, and pursue justice as a result of international cooperation. Uruguay is fortunate to have a dedicated and patriotic class of new citizens who wish to be acknowledged as Uruguayan. Perhaps it is time to listen to Orson Welles, who spoke about nationality in a manner diametrically opposed to that in Uruguay. Welles tells us, "A man is not from where he is born, but where he chooses to die." The fight for full and recognized nationality for legal citizens in Uruguay will continue. The fight, according to some, is to obtain the right to truly belong to that place from where they are from, their new home. The struggle is for the right to choose one's identity. The result, many believe, will be the redemption of Uruguay's human rights record and a restoration of the original Uruguayan constitutional spirit of equality and inclusion.